I think we're close enough here. If anyone comes in, they'll just have to join where we left off. But in any event, you are here for the Herzl Law webinar, Everything Your Community Association Needs to Know About Collecting Assessments. So if that's what you were planning to attend, then you're in the right spot. If not, then feel free to stick around and listen to collection talk. My name is Matthew Markley. I'm an associate attorney here at Herzl Law. I am located in the Farmington office. We do have offices in Chicago, Traverse City, and Grand Rapids. Farmington is our main office. If you'd like, you can take down my information here so you have it. You can also access it on the website. Not with us tonight, but also in the collections department is senior attorney Chantel Newman. It's possible maybe some of you out there have worked with either her or I, but she is also a part of the collections department at the Farmington office as well. So without further ado, let's talk about associations and collections. So what we're going to talk about today is a summary of many different topics. These obviously can be nuanced, but we'll do our best here to kind of dive into the big details of each different area of basically how to go about collecting and what's important. And then hopefully you can walk away with something that will be useful to bring to your association. Or you may have a legal issue that you believe you've done the best you can, and now it's time to get a legal office involved and start the formal collection process through an attorney. So what we're going to talk about today is the role of the board of directors, the role of the property managers, the different types of delinquencies, collection policies, timelines for collections, legal action, lien priority, lawsuits and foreclosures, enforcement, a little bit of bankruptcy, and then just to touch on some best practices for streamlining some of the payment and options that associations take to try to keep everybody current on their assessments. I would say that the enforcement and the collection of assessments is probably one of the most fundamental aspects of running a successful association. And notably, board members do have a fiduciary duty to collect and ensure that assessments are being collected for their association. So you have two important things going on when it comes to collections. Streamlining and making sure your association is properly funded and running smoothly from a functional standpoint, and then obviously the fiduciary standpoint for the board of directors. So let's talk a little bit about the board. So, the board comes into play. Their main role in this aspect of running an association, the collections aspect, is obviously ensuring that accounts are not delinquent, making sure that their funds for the association are accurate, and that they have the money to be able to do what they need to do. In line with that is keeping accurate records. So what board members want to ensure they're doing for their association as a whole is obviously making sure that they have the names of their owners. That seems simple, but sometimes different owners have tenants or co-owners have tenants in their units. So you want to make sure you know who's living in what home or what condominium. That comes into renters and tenants. Sometimes people have investment properties. So you want to know if you have a tenant living there or is it the actual owner, because that's going to affect where you need to send notice, how you need to send notice, and frankly, how you can keep in touch with the individual who owns it. Offsite mailing addresses, that also goes back to potentially people could own units or properties as investments. And so if you're going to send notice out, whether it be a collection notice or just a general notice of an amendment or something in the community, you're going to want to make sure that you have their secondary or what would be their primary mailing address, secondary being the subject unit or property. And that is very important, at least from the collections end. I see that a lot where it's an investment property and the owner is in collections with our office and they come in to us and they say, well, I told them I lived at X address and they didn't send me notice there. So that can create issues with the collection process. So you want to make sure you have that information down and accurate. Also, on the flip side, the owner or the co-owner, they have an obligation as well to the associate to make sure they're updating you with that information. You can't send something to a place you don't know exists. In line with that, email addresses and phone numbers, once again, not necessarily, completely for collection purposes. It could be if they consent to receive emails from the association, but more so for emergencies and just keeping contact. Lastly, and importantly, you want to make sure that you keep records of payments in order to ensure your association is properly funded and owners are not delinquent, or if they are, you need to make sure that the payments are being recorded, the check numbers, when it came in, how it's applied, everything like that. It streamlines the process. It also ensures that if you do get to the collection stage, that the accounting is accurate. The board will also work with various partners. Two of the main partners would be property managers or attorneys. It's important that the board establish relationships with these two different groups. The property manager will typically be a liaison between the board and an attorney or a co-owner. So it's important that they're, the board and the manager are aligned in their goals and what exactly is going on with the community. Obviously, the board will work with attorneys on a variety of issues, here being collections. It's possible for bylaw violations, governing document amendments, etc. So the board will work with those groups and hopefully everything will function smoothly. Clearly it does not, otherwise we wouldn't be in business, but we can certainly do our best to try. A little bit more on the board. It's important that the board doesn't ignore delinquencies. You want to stay informed on the status of accounts in your community to ensure that you know who is and who isn't on time. With that said, though, you want to be flexible. You don't want to be aggressive or cause confrontation when it comes to delinquent co-owners. You want to be able to work with people when you can and try to resolve. I mean, that is the name of the game here, is to, keep everybody in line with what's going on, but not create personal issues that lead to difficult situations down the line. Importantly, for collections, you want to treat everybody the same. Now, you'll note here on the PowerPoint that every case is different. And that is true. There's not a single case that is the same. Everybody has different circumstances, different issues arise, things of that nature. But the importance is that everybody is treated the same. Now, how does that work? Well, if the board is amenable to waiving late fees for one person, they have to waive them for everybody else who might inquire. You don't want to run into a situation where the delinquent owner is, claiming discrimination or selective enforcement based on the board's treatment of one delinquent individual in the community over another. And that is very important because we want to try to keep any claims of discrimination or selective enforcement, away from the process and just streamline everything. As far as communicating, obviously the board is going to do communicating with the association or through the property management company, but it is important that you have everything in writing. It's very important if it transfers over to a legal office for collections that obviously we have records of what exactly went on before it came to us. You can do that via email as well. You can even send notice via email if the individual has consented and you know that you have a valid email address for them. You always want to be professional. I think that's obviously easier said than done, but there are situations, especially when it comes to money and collecting, that people can make things personal, but we want to keep everything even keel at a professional level. And then obviously you want to avoid confrontation. Again, that just comes down to, there's no need to engage in any personal attacks or anything like that. It just makes the situation harder to resolve. and if you turn issues personal, nothing moves forward. And our goal here is resolution. Okay, so property managers. So some communities, maybe some of you who are attending, utilize a property management company. The expectations of what that management company will do for the association is going to be spelled out in whatever agreement you may have with them. I know some use them solely for accounting purposes, others use them for full-scale management in dealing with my a legal office or anything like that. So that's going to depend on what kind of agreement you have in place. The property manager, one of their main roles is to obviously be informed on what is going on with the community. They'll draft board meetings, attend board meetings, draft minutes, and review and do that sort of thing. They'll also provide status reports if requested by the association. Attorneys will also provide status reports if requested for collection purposes as to what accounts are delinquent, what exactly is going on with certain files. The property manager will act as a liaison between the owners and the attorneys. So typically how that would work is they would mediate between the board, potentially an owner, and then our office as far as the collection aspect. They will probably send delinquency letters before anything gets turned over to our office, and they'll usually provide that to us so we have a record of prior notice being sent. And lastly, they will likely relay payment plans or payment proposals from a co-owner or from my office to the board for discussion and consideration. So I guess the main question is why do members of communities become delinquent? Well, there's a variety of reasons. Some unfortunate situations happen. Individuals fall in hard times, obviously lose a job, medical expenses. COVID-19 was obviously an issue for a lot of individuals with not being able to pay certain portions of their bills, assessments being one of them. Members may not pay because they're renters or they're investors. And typically what happens is an investor comes in, they rent their unit, and they don't leave an offsite mailing address, so there's no way to get in touch with them, and then they don't pay their assessments because they forget about it because somebody else is living in the unit, or the tenant doesn't know that per their agreement they're responsible for the assessments. So that's a popular issue, is the rental property in no secondary address. New management companies, when a management company comes in, obviously previous management auto pays are typically canceled, and that has to be restarted with the new management company. So it's not uncommon for individuals to believe that their auto pay is still going, even though it's not. It's canceled, or it's still going to the other management company and obviously not being applied. Abandoned properties can lead to delinquencies. Obviously, if an owner passes away and there's no estate or anybody there to take care of their assets, then there will be delinquency. And then repeat offenders, there's careless individuals out there. There's also other individuals that just don't care. If they get charged a late fee, they'll pay when they feel like paying. And so that will just be a cycle that they, for whatever reason, decide that that's how they want to handle their business. Okay, so angry members. So another reason members may not pay their assessments is that they're angry with the association for whatever reason. Bylaw violation, a new special or additional assessment that they're not happy about, maintenance disputes over issues with their unit or their property. As far as whether they can withhold those assessments, MCL 559-239 for a condominium, that's the Michigan Condominium Act, a co-owner may not assert or withhold their assessments for any reason, whether they're upset with the association on a personal level, whether there's a leak in their unit, whether they just passed a new amendment that's not sufficient and they can't withhold that or escrow it or use it as a set off for collection purposes. They have the right to seek counsel and file a lawsuit or go through that process if they believe that the board has done something wrong. But simply saying I didn't pay the assessment because there's a leak in my apartment that hasn't been fixed is not a sufficient answer, and assessments must still be paid. Okay, collection policies. So what exactly is a collection policy, and why should an association consider, if they don't already have one, implementing one? So a collection policy provides a framework for how the association is going to deal with delinquent accounts. What it does is it basically takes what's called for in the governing documents of the bylaws or the restrictions if you're a homeowners association. It puts everything forward on paper and says A to Z, this is what happens if you're delinquent, and here's the timeline, and here's how we're going to find a resolution. It like I said, it spells out timelines for how long the association is going to allow and deal with somebody who's delinquent before turning over to a law office or a collections agency for collections. It could also discuss payment plans. If the association is going to consider payment proposals for a past due balance, how would they handle that? Are they going to allow a payment plan for a certain amount of money for X time? Are there no payment plans? How would that work? Once again, the goal here is to provide a document to your association so that everything is laid out and there's no ambiguity and there's no question about what's going to happen. Lastly, you'll lay out the legal procedures and what will happen when an account is turned over, if not resolved prior to. Obviously we'll send a demand, a lien, foreclosure, etc. You'll want to lay all that out in the policy. Importantly, your policy cannot conflict with your existing governing documents. So you can't write something in that you don't have the authority to do. For instance, if your documents don't call for late charges, but you put in your policy that you'll charge $50 each month that somebody's delinquent, if that's not already in your governing documents, or there wasn't a resolution or something previously passed, that cannot be in there. You'll have to amend your documents accordingly to reflect that language to then be able to put it in your own collection policy. As far as attorney review, if you have a collection policy, obviously your attorney can review that and provide for any legal updates for any changes. If you don't have a collections policy, an attorney can draft you one that mimics and aligns with your governing documents to help you with the collection process, and really avoid any issues or challenges down the road for that. So where you have a collections policy, maybe you don't, but we'll assume you do. A member's delinquent, what happens next? So these dates here, the 15, the 45, and the 60 are just examples. You don't have to follow this. If you already have a collection policy in place, you might have different dates and timelines for how you'll handle a delinquent account. If you don't, and you'd like a collection policy, or you just like to have something in place where you're following a timeline, this is a recommended timeline from our office, and it's relatively helpful. So what will happen is if a co-owner is 15 days delinquent, you'll send a notice letter to them, either by the board or the property manager, depending on how you have your association set up. Obviously, if it's self-managed, you'll write board of directors or association, and you'll give them the notice and see if they can correct the problem. Again, the goal here is to get somebody back on track. Maybe they forgot, their auto pay failed, whatever reason. Just a reminder, hey, this is past due. If you get to 45 days, you'll want to send a second notice, once again by the board or the property manager. At that time too, you might also want to look into and see if you have an email for the individual. Perhaps you can try to send the notice that way. You might want to check to see if you have an offsite mailing address. Again, if it's an investment property, it's likely that the actual owner isn't residing there. So you may want to check to see if they gave you a secondary address. So you could try to get in touch with them and get it resolved before it gets turned over. You get to 60 days and the account is still delinquent. You've done your due diligence. You can't get a resolution. You can't get in touch with the person, or you do, and they tell you, they ignore you. We do recommend that at that time your account should be turned over to our an association's attorney, and from there we'll send a demand letter and start our legal process for how we can collect the past due assessments. Notably, once it's turned over, you'll want to avoid personal contact with the delinquent member. You don't have to completely ignore the individual, but you'll just want to ensure that you tell them that the communication needs to come through the attorney's office, as they're the one handling the account. That will help streamline the process and will also keep from other conversations that may not be known to the attorney, or little side agreements or whatever may take place that we'll find out later in time. It's helpful if we can just keep one channel of communication, and that way everything can come in and out of the attorney's office, and there's no issues or questions related to what somebody else may have said. This is just a little slide, a little comment on delinquent members here. So bad ideas. So there's privacy laws out there. There's the FDCPA, which is the Federal Debt Collections Practice Act. There's the Michigan Collections Practice Act. And so some things that you don't want to do when you have a delinquent member is you do not want to publish a list. You don't want to say, hey, these 10 people haven't paid in a while. Let's send this around the community. That violates their privacy rights. It violates the FDCPA. Same thing. You don't want to send email blasts. You don't want to call them out. And then you don't want to confront them either. Once again, once it's turned over to an attorney for handling, they're the ones handling and controlling the communication. There's no need to, ruffle any more feathers than probably already ruffled with it being turned over to an attorney. So when to get legal involved? Like I said before, typically we say after 60 days, plus when there's 2 prior letters sent by the board or property manager, that's when we recommend a turnover. As far as the distinction between a condominium association and a subdivision or an HOA, if you have regular monthly assessments and you're a condo association, then that's 60 days. If it's an HOA with relatively low annual assessments, then we recommend 2 years or more of delinquency before we really do anything. If it's an annual assessment that's more than a few $100s, then we would have to look at the situation, but we may recommend recording a lien, just because there's so much time in between the assessments and the amount of the assessment that we wouldn't want that individual to try to get out of paying that by selling the unit or doing something, transferring their interest before that money is accounted for. Statute of limitations. So the statute of limitations is going to be, what are you able to collect and how long do you have for collections? So for condominiums, the statute of limitations is 10 years. What's notable about that is it's a fairly long period of time compared to a subdivision. It's typically, a standard statute of limitations is a few years, so 10 years gives you a lot of wiggle room there. If you're a subdivision, your statute of limitations is going to be 6 years, and that's based on the Michigan breach of contract laws. It's possible that you could have a longer statute of limitations, though. It depends on the circumstances and how the governing documents are written. And so that will depend, but your default is 6 years unless it's written differently. Okay, so you've done your due diligence, you've done your first steps, 15, 45, 60 days, you've decided enough is enough. It's going to the attorney's office. What exactly are we going to do? That is going to be different. So typically the standard procedure that we do is that we'll send a first demand letter. And what we do is we'll do a title search, we'll confirm ownership, retrieve the deed, do everything like that, because under the FDCPA, we're obligated to ensure that we're sending notice to the proper party. So we will go through and make sure that whoever is listed on the accounting provided by the association is actually still the owner. We'll also determine if there's any mortgage on the unit or any tax liens that could affect the association's ability to foreclose or their foreclosure position, their lien position. We'll do a bankruptcy search. That's important because if a co-owner or an owner is in bankruptcy, that will change the process and the scope of how we collect, depending on if it's a Chapter 13 or a Chapter 7 bankruptcy, which we'll talk about a little bit later. We'll do a tax record search. This will help us locate possible alternative mailing addresses or if there is a renter. And that will be important, again, so we can get notice to hopefully where it needs to go so we can get a response. What we'll do after that is we'll take a look at the association's accounting and verify all the charges on the account and that they're accurate and that everything is proper. For instance, one thing that we'll do at the very beginning is we'll ensure that the account either is at a zero or a credit balance. Under the FDCPA, you have to verify the debt. And so the way you do that is by going back to whenever that person was at a zero balance or a credit balance. And then our fifth step in the beginning process here is we'll send a demand letter. And that demand letter will give them 35 days, it's 30 days plus 5 business days to receive our letter and either dispute the debt and go down that route or contact our office, make a payment, etc., work out a payment plan, something like that. So that will be the typical first process, at least at Herzl Law, for handling a delinquent account that's being turned over. It's not set in stone. It's possible that depending on the situation, we may record a lien first, but it is fact specific, and it will depend on the particular situation at hand when it's turned over. Okay, so calculating balances. So like I said before, we'll review the accounting and we'll make sure that everything that is on the accounting is proper and allowed to be charged. So we'll look at the accounting and make sure that there's no issues with the statute of limitations. So if something is going back to 15 years, and it's a condo, we'll make sure that we can collect the 10 years. If it's a HOA with a 6-year statute of limitations, we're going to make sure that whatever we're allowed to collect, we can collect. We'll make sure that any special or additional assessments, we have the documentation and the association's documentation to show that those are properly being levied, by the board minutes or the amendment vote package or whatever it may be. A lot of accounts may have late fees. A lot of governing documents do allow for late charges for delinquent assessments. We're going to make sure that those are reasonable. And what I mean by that is it has to be reasonable in compared to what the assessment is. So, if you have $100 monthly assessment and you're charging a $100 late fee, that probably isn't going to be a sufficient or reasonable late fee. Late fees, what you're looking at is a reasonable estimate of the administrative costs and other damages incurred by the association for having to deal with the delinquent account or the late payment. So you have to justify to a degree the work that needs to be done because of somebody being delinquent or late in the payment. As far as interest, governing documents may allow for interest to be applied to the account. 7% is the legal rate. If your documents call or indicate language such as, the legal interest can be charged at 10%, but doesn't provide any other language in there, or the legal current rate or something like that, then we wouldn't be able to charge that because we don't want a usurious it would violate the usurious law of interest. So 7% is what we would be looking for. It is possible that you could add it. Again, you would have to amend your documents, though, to change the language depending on how it's written. We'll also look at fines. Typically, subdivisions don't have the right to fine unless it's written in the documents. So if we are doing work for a HOA, we'll make sure that the documents allow for the fine. If it's a condo, I'll get to this. I believe it's on the next slide, but MCL 559-206 allows for the levying of fines, and there's certain procedures that have to be met, ensure that those fines can be included in the collection amount being sought. And then, of course, we'll look to see if there's any other collection costs. Sometimes management companies have their own administrative fees that they charge for turning over an account, for late charges, sending notices, etc. So we'll read through all that as well, look at the agreements and make sure that any charges that are being listed through the management company are proper and allowed based on the agreements with the association. So special consideration for fines. So like I said, under the Michigan Condominium Act, the association can levy fines if it finds it's necessary. What's important about this, or I guess I'll back up just to clarify between a fine and a late charge or a penalty. So a late charge obviously is for delinquent payment by X date. A fine is going to be something related to the bylaws, such as not taking trash cans in, not cutting grass, not properly following with what's written in the bylaws or the governing documents as far as what the association requires. So MCL 559-206C says such other reasonable remedies the condominium documents may provide, including but without limitation the levying of fines against co-owners after notice in a hearing thereon. So this is actually really important. If you're an association, you have a delinquent member and fines are on the ledger. You can't just send notice to the co-owner and allow them to request a hearing. You actually have to send them notice, have a meeting scheduled and set that they can attend, and they can come and attend and discuss the delinquency. And the association is still within the right to find that they violated whatever the bylaws stated that they're being told that they violated. But you can't just send them a notice and say it's a $50 fine because you didn't take your trash cans in. They have to have that hearing. And then, if they don't show up, that's their problem. But you have to provide them with that notice in order to be able to include any fines in the delinquent balance. Late fees. So we talked about the reasonableness of late fees. A couple other considerations as to why late fees, can be helpful. They can certainly be a bargaining chip as far as account resolution. Late fees typically aren't budgeted for by the association. They're typically penalties to the delinquent owner or co-owner. And so by that, you can waive them possibly or reduce them in order to get somebody to resolve their account without affecting the rest of the community. Now, remember, you have to be equal with everybody. So you can't do it for one and not the other. But it's not unlike, legal fees or something. It's not a charge that is being divided up between the other members. It's solely for the delinquent. So you may consider waiving late fees. For that reason, you might use it as a bargaining chip for a reduction. With settlement agreements, that may also be the case. You may have an individual that says, look, I know my balance is $10,000. I'm willing to pay $9,500, but I need the $500 in late fees waived. Well, for amicably and quickly resolving accounts, that might be something you would consider, waiving the $500 in late fees in order to get paid in full, get the account current, and move on. Because again, the goal is account resolution. Payment plans, typically payment plans call out for and indicate that if an individual is following their payment plan, then no further late fees will be charged. Again, the goal is resolution. So if you're still charging late fees on a payment plan, they're going to keep accruing a balance and not be able to get it paid. So you will want to consider that if there's a payment plan in place. And then, of course, we talked about the reasonableness, so I won't need to rehash that. Okay, speaking on payment plans. So payment plans can be very useful, and they can be very helpful to individuals who don't have the means to pay off their account. Once attorney fees are added, late charges, interest, etc., it can become, a lot to handle, and depending on their situation, they may not be able to pay it all at once. But we don't necessarily want to, take further action or foreclose on an individual. You want to give them an opportunity, if possible, to resolve their account. So a payment plan will help minimize legal fees, because what it will do is it will allow them to make their payments, obviously, over a certain period of time, and it will not involve a legal office continuing to charge costs on the account in order to collect. It may help an individual avoid bankruptcy if they're in a situation where they owe X amount of dollars to the association and they know they can't pay it. They may file for bankruptcy. If you have a payment plan in place that's reasonable, they may be able to avoid doing that. And if they avoid doing that, then obviously they'll avoid them filing bankruptcy. It will also lower the amount of fees that will come with doing that. Filing bankruptcy is expensive, but it will also mean the collections attorney will have to incur costs in order to ensure the association is paid out of a bankruptcy proceeding. As far as how you want to go about payment plans, kind of obvious. You want to make sure that you have a document in writing. You want it signed. You can have it prepared by the attorney. It's relatively straightforward, but you just want to make sure everything's spelled out, everything's in writing, and everybody knows exactly what's happening. You can give the attorney or the property manager the authority to enter into payment plans. If you spell out that an attorney can enter into a payment plan if the delinquency is below a certain amount of money and they have X amount of time to do it, then that streamlines the process, because now the attorney can directly handle that and not have to go back to the board or the manager in order to get the approval to be able to do it. So the big question is you've entered a payment plan with a delinquent owner and then they stop paying. What exactly are your remedies? Simply put, if you stop paying under the payment plan, the association has the right to continue its collection procedures, and that's exactly what will happen. Typically, too, as I noted earlier, late fees and maybe interest can get suspended on a payment plan if timely payments are made. If the payments are in default on the plan, typically we can go back in and add the late fees back on as a penalty for not following through with their obligation or the interest. Once again, if you do a payment plan, you might do one without the attorney's office. This could take place after you send your first delinquency notice. So after default, you may then send it over to an attorney's office to handle, or we might put a lien. Whatever the process is, you can pick back up where you left off if it's not followed. Okay, so liens. What is a lien? It's a recorded document that puts others on notice of the association's interest in the debt on the property or the unit if it's a condominium. As far as the timeline goes, our office will typically, like I said, start with the initial demand, and that will provide them 35 days to respond or pay. If we don't get a response, typically what we'll do is our next step will be a lien. So we'll go ahead and draft a lien. We'll draft a letter with the lien, letting the co-owner or the owner know that a lien is being recorded against their property. We'll send that certified mail. We'll also then give them 14 days to pay in full. And we'll also mention, if the government documents provide for it, if it's a homeowner's subdivision, we'll mention the foreclosure remedy as a next step if we can't get a response from them or some sort of resolution. So when we record a lien, it's similar to a mortgage. and it will protect the association's interest. An individual won't be able to sell or refinance or make changes with that lien there. Typically what will happen is if somebody goes to refinance, the title company and the mortgage company will pull title and see that the association has a lien. They'll send information over to the law firm or the association saying, hey, we note the lien here. What's the payoff, or how do we go about this? And then we can send the payoff. This happens quite a bit when people sell their homes or their condos during the collection process. It doesn't prevent them from selling it. All it does is prevent them from selling it without paying us, which is the important aspect of that. Is once again recording the interest so that the association can protect its interest in the unit. Okay, so related to liens, Michigan, we have to look at the recording statute. Michigan's first in time, first in right. It means, frankly, if you're the first person to record your interest, then your interest will have priority over the other interests that may file. So think of a mortgage, tax lien, etc. Now it's more nuanced than that, and we'll get into that on the next slide, but that is the general gist. Michigan, more specifically, is a race notice. So as long as you record and nobody, you don't have notice of another interest, then you'll take priority. That's spelled out in MCL 56529. I won't read that paragraph to you because it boils down to what's in blue there. The first interest holder of record takes priority unless that person has notice of a prior unrecorded interest. So nothing can ever be that simple. So there's priority depending on the type of lien that is recorded against a property or a unit. So I'll go through each one of these boxes, and then there's obviously there's going to be a few more nuances on top of the nuance. So if we're looking at city or township property tax liens, those will take absolute priority, and their foreclosure will extinguish all other interest. So if there's a township tax lien, and then there's the association's lien that was recorded after that was recorded, well, frankly, it doesn't matter. They'll take priority regardless of when the association records their lien, and it will wipe out the association's lien. So those will take top priority. State of Michigan tax liens must be recorded to obtain priority over subsequent interest. So that's basically the standard Michigan recording statute, the race notice. Federal tax liens, they must also be recorded to obtain priority over subsequent interest. Construction liens are a little bit different. Those must be recorded within 90 days after the last date on which labor or materials were furnished. The construction lien will have priority over all other interests that are recorded after the first actual physical improvement to the property. And then notably, their action to foreclose must commence within a year of recording the lien. That's specific to a construction lien. A condominium lien has priority over second mortgages. There is a conflict in law between the construction lien and the condo lien priority. It's not clear exactly on how those two work themselves out as far as priority goes. So we are monitoring the case law to see how that one ends up getting resolved. But as of now, just note there that a flag, if that's an issue you're dealing with, that there's a conflict of law there, and we'll have to work on that and see exactly where the law goes. Okay, so condo lien priority over a second mortgage. I already kind of discussed this, but simply put, a condo lien will take priority over a second mortgage. I'm not sure exactly what else there is to say there. MCL 559-208 spells out or discusses the lien priority, which basically says that the condo will take priority over a second mortgage, except tax liens and first mortgages. So there is an interesting case, Yarmouth Commons Association versus Norwood. This has to do with condominium association lien and a federal tax lien. So as I just said, actually, in that on this slide here, MCL 559-208 says that the condo lien takes priority over second mortgage except tax liens. Well, in the case of Yarmouth, it was a federal court case, and the federal court indicated that because the condo lien was recorded first, it would take priority over the federal tax lien. So there's a little distinction there and a little bit of a conflict as far as the way the Michigan Condo Act is written. But the federal court gave the condominium association full priority over the federal tax lien because the condo lien was recorded before the IRS recorded their lien. Okay, deed in lieu of foreclosure. Now, this is a less common situation, but there are situations where a homeowner, may be in the position of getting foreclosed, and they don't want to be foreclosed and have that judgment against them. So there's a situation where they may be able to walk away from the property without being liable for the judgment, obviously giving the deed to the interested party, in this case, to the association. It's also beneficial for creditors who want to avoid the foreclosure process and the redemption period, which is a notable period of flux, and they want to obtain ownership. Sometimes this can also happen if an individual just isn't delinquent, but the property's underwater or something like that. As far as associations go, they should never accept the deed in lieu of foreclosure if there's other liens or mortgages on the property. This case here, Stonehenge Condominium Association held that an association lien had priority over second mortgage, but the association lost that priority when it accepted a deed in lieu of foreclosure. So they were no longer in priority. And that means that those other interests can foreclose or do what they want. And now the association is stuck with the fact that there's a mortgage that's going to foreclose. So it's a unique situation when deed in lieu of foreclosure is a good idea. And so it's possible, it's a concept that's out there, but it is a little bit nuanced, and we would want to take a look at the different interests or liens that are on the unit. Okay, so if you're following along with my timeline for a turnover to an attorney's office, I started with the initial demand. I then went to the lien and secured the interest against the unit through a lien. Now we're at the last stage. We don't get a response. Maybe we try to follow up demand, etc. Nothing's working. What do we do now? So one of the options is you can file a lawsuit for a money judgment. You can also do a lawsuit for a money judgment and foreclosure, depending on the situation. So filing a lawsuit is an option. The pros to doing that is the judgment lasts 10 years as far as collections. If you know that the individual has assets that can either be garnished or seized, then it makes it a more fruitful avenue to take. It's not helpful if you file a lawsuit against somebody who doesn't have assets or a job. It's going to be very hard to collect. So that's a pro, is we can go ahead and seize those assets to pay off the judgment. It's a typical method we prefer to do it, obviously, when there's no equity in the property. So foreclosure wouldn't be a proper remedy because the association doesn't want to take the risk of taking a unit in foreclosure that's underwater. The cons of a lawsuit is that it is time consuming. It can take 4 to 8 months. It's relatively expensive. You have to go through the lawsuit procedure and the discovery, the different procedures involved, court hearings, etc. You have to locate and serve the owners. If you don't know where they live, that can cause headaches as you're trying to get process servers out there to find them. It gives the owners the opportunity to contest, raise defenses, which only therefore complicates the litigation and could drag it on longer if they're bringing counterclaims and things like that against the association based on the lawsuit. Lastly, and I think this is, a very important note to bring up, and if you're taking notes, I might star this one. The court must approve the legal fees, the late fees, etc. So importantly, if an association, especially this is written in the Condo Act, it indicates that the delinquent co-owner will be responsible for all legal costs and fees associated with the collection. So if you go ahead and then involve yourself in a litigation and you're under the premise that, well, the bylaws say the co-owner is responsible for the $10,000 we just spent legal fees, unfortunately, that's not the way it works. So the judge actually will make a determination on the reasonableness of the legal fees charged. So it's not uncommon where the judge will almost always reduce the fees to some extent. So for example, on that $10,000 one, it's possible that the judge might find $6,000 were reasonable and only award that. And now there's $4,000 that is obviously to be paid by the association for the legal work. But that is an important caveat that should not be overlooked. Our office certainly does our best to make sure that that is reinforced every time it becomes relevant, to make sure that the association is not in a position where they think they're going to get exactly what they spent. It would be nice if that was the case, but obviously that will be up to the judge, and they don't have to award what we request. Okay, so the other option, we decide that we don't want to file a lawsuit. Our office typically recommends foreclosure by advertisement. If we can, it's our preferred method. It's a shorter period to get the work done, and it typically gets the co-owner or the owner to respond relatively fast to resolve their balance, based on the fact that this process is fairly quick compared to a lawsuit. It's cheaper than a lawsuit. It's typically around $1,600, give or take. It's fast. Foreclosure by advertisement in Michigan only requires 4 weeks of publication. After that 4 weeks of publication, the sale will be set, and the sheriff will actually hold the sale, hold the auction at the circuit court in the county in which the property is located. So it will go to sale. There's a threat of eviction as well for the delinquent owner, because after the redemption period, they're going to get evicted from the unit because now they're no longer the owner. The cons with foreclosure by advertisement, or the risks, is that if nobody outbids the association at the sale, the association will become the owner of the property. How exactly does that work? Well, what we do is that if the association is owed $10,000, we will submit a credit bid on behalf of the association for the $10,000 as the starting bid. If nobody bids on the unit at the sale, then that unit will transfer with no monies being transferred to the association via that credit bid. So they'll take ownership subject to the redemption rights of the owner. If somebody does bid even $1 over, then they will take the unit subject to the right of redemption, and then the association will be sent a check for whatever the delinquent balance is. So it's a fairly quick process. It works well. The risk is that sometimes the association might not want to own the unit. The unit could have some issues as far as tax liens or other issues that they may not want to deal with. The debt then becomes extinguished. So if the association ends up getting the unit, that's what they get in lieu of a check for the delinquent balance. Now, that could be helpful. There's a lot of potential opportunity that the unit has equity. So if the association takes the unit, deals with the redemption period, and sells it, they could possibly make a profit on what they were initially owed. So there is some upside there that you obviously don't get with a lawsuit. The last thing I'll touch on here is the 6-month redemption period. So the standard statutory redemption period in Michigan is 6 months. There are 2 ways that can be shortened: abandonment or the statutory inspection process. Abandonment, kind of as stated, if let's say the owner has passed away, nobody lives there, it could be reduced to 30 days. Or there's the statutory provision in which the association can request an inspection be done if they believe that the unit is damaged or will be damaged based on the foreclosure. They can have somebody go in, inspect, and if there's harm via the damage, then the redemption period can be shortened that way. So those are a couple options of dealing with a foreclosure and the redemption period. Okay, so I have 3 examples, and this relates to what we discussed as far as a lawsuit or foreclosure, and kind of brings the priority and lien priority issue into play. So I'll just go ahead and go through the examples. If you'd like, I'll give you a couple seconds if you'd like to put in the chat, what you believe the answer to be. That's fine, and then I can explain. And if somebody has a question, feel free to put in the chat or chime in. That's fine too. Okay, so an association is owed $5,000. The property is worth $100, and there's no mortgage and there's no unpaid property taxes on the unit. Should the association file a lawsuit, or should they foreclose? I'm not seeing anybody who wants to give it a shot, so I will give you the answer to this one. So, given this situation, our office would recommend foreclosure. There's $100,000 equity or value of the property. Only $5,000 of that is owed. There's no mortgage and there's no unpaid property taxes, so there's nobody ahead of the association as far as lien position. So we would certainly recommend, in this case, the association foreclose. And there's the possibility as well that if the association does take title to the unit at the sale, they have potentially $95,000 in equity there that they could work with. Okay, we get a little trickier here. The association is owed $5,000. The property is worth $100,000. There's a first mortgage of $90,000, and there's an unpaid property tax of $15,000. And same question: should the association file a lawsuit, or should they foreclose? So in this situation, we would recommend a lawsuit. It appears based on the facts that the unit is underwater. So there would be no upside to the association initiating a foreclosure when there's all these other interests that would have priority over the association's lien. So we would certainly recommend proceeding with the lawsuit here. And the last example, the association is owed $5,000. The property is worth $100,000. There is a first mortgage of $80,000. There's a second mortgage of $30,000, and there's no unpaid property taxes. Should the association file a lawsuit, or should they foreclose? As far as an answer to this one, if you're looking at it through the lens of the Condominium Act, you would see, you would know that, okay, the condo lien has priority over the second mortgage, so that would wipe out that $30,000. Then there's still $15,000 in equity potentially, even after the first mortgage is paid off, in the $5,000 from the association's lien. If you're looking at it through the lens of the standard HOA subdivision, where the condo, there's not the specific language of the Condominium Act, you would basically look, and this question, I guess, could be worded slightly better with better facts to let you know that the lien was recorded first, and you would still get the priority over the second mortgage. So in this case, we would likely still proceed with foreclosure in this instance. Additional enforcement actions. So there's a few more steps that you can take depending on the situation for delinquencies. There's acceleration clauses. So there are governing documents that allow, in the event of default, for assessments for a fiscal year to be accelerated and immediately due and payable. We don't recommend this in the early stages of a delinquency. Again, the goal is resolution. So if somebody's 1 or 2 months late, accelerating the remainder of the year could make it impossible for them to pay if they couldn't pay before. So that would not be helpful to a successful collection. Typically, this gets exercised at the lien or the foreclosure stage. If we've already attempted communication and we're not getting a response, then you can certainly use the acceleration clause to add a little bit of pressure there. Rent diversion. This is typically for condo associations, and what it does is it allows you to send a letter to the tenant and say, the owner of this condo isn't paying their assessments. We are now asking you to pay them in lieu of paying your rent to the owner of the unit. And then if they don't, it will, the bylaws and the law allow for an eviction of the tenant who doesn't pay. So it can be a lucrative tactic to try to get payment of a delinquent assessment. And on the next slide here is the specific language of the Michigan Condominium Act, MCL 559-212-5. I'll read just a little bit of it. When a co-owner is in arrearage, the association of co-owners may give written notice of the arrearage to the tenant occupying the condo. After receiving the notice, the tenant shall deduct from rental payments due to the co-owner the arrears and future assessments as they fall due to pay them. The deduction does not constitute a breach of the rental agreement or the lease by the tenant. And then if the tenant, after being notified, fails or refuses, the association may do the following: issue a statutory notice to quit for non-payment of rent and start the summary proceedings. So that is an option available to condo associations as far as a collection remedy, and it can be helpful. Typically, a tenant will then call their landlord, and I'm not sure exactly what their discussion would be, but I'm sure it's not a happy one. And typically, then a resolution comes after that, because nobody wants to be evicted from their unit, and a landlord does not want an unhappy tenant. So that is an option. A couple more enforcements. Voting. A typical penalty for delinquent members is they'll be ineligible to vote. They can still attend the meetings, but they won't be able to be a part of the voting process. They won't be able to run for office either. You can't serve on the board of directors if you're delinquent. A lot of the documents will outline that owners in default may not be permitted to utilize the common or the recreational facilities. So, a gym or a pool or whatever the association community may have. The importance of this is you can't deprive the owner of ingress or egress from their home. So they still have to have the ability to get in and out of their dwelling. So yeah, you can tell them they can't use the gym, but you can't stop them from, getting into their home. Bankruptcy is noted here. This is important because you don't want to violate the automatic stay of a bankruptcy. So if somebody is in bankruptcy, you can't withhold their ability to use these facilities because it would be considered a collection remedy against a co-owner in bankruptcy or an owner in bankruptcy, and that would violate the automatic stay provision of a bankruptcy. Another enforcement action that can be a little bit tricky is association is, if the documents call for it, allowed to shut off the owner's utilities, and they must typically give 7 days notice. This one, if the association is in a position where they feel like they have no other choice, then it may, if the governing documents allow for it, they can exercise that remedy. Although I will say judges typically do not like this enforcement tool. They will typically issue a temporary restraining order to have the utilities turned back on. So that is one thing to keep in mind. If the association feels like it needs to be done in order to, get the co-owner or the owner to comply, then they can certainly move for it. But the judges typically don't like it. Noting again, bankruptcy, once again, you can't violate the automatic stay. So you wouldn't be able to turn off the utilities in that situation. Briefly, there are assistance programs out there for individuals who are delinquent and can't pay their association dues. The Michigan State Housing Development Authority's Step Forward program, that did close on June 30th, 2021. There is the Michigan Homeowners Assistance Fund, better known as MIHAF, and that opened in February of 22. And it was for those impacted by the pandemic. An association can become a participating partner, and they can complete an agreement. And a service provider of the MIHAF will contact the association of the property management company if one of the community members is unable to pay their condo assessments or homeowners assessments, and they will help facilitate a payment to help obviously grant them the money to be able to become current. A little bit more on that, there are requirements to qualify. Homeowners with household incomes less than 150% of the area median. It has to be their primary residence. They must have a financial hardship directly related to COVID-19, on or around after January 21st, 2020. It's up to $25,000 per grant household, and it will pay, not just assessments, but mortgage, housing expenses, property tax, land contracts. There's the association fees, insurance, electric, water, utilities, internet, etc. So that is an option. Our office does deal with individuals who utilize this, and they work with the association, the property management company, to get the funding in place. It is $25,000. So if their delinquency is above that, they can obviously only max out at 25, and they'll have to find a way to resolve the remaining balance. I see that I'm a little bit over time here, so I'll try to speed up for you all. Bankruptcy, there's two types. Chapter 7. If an individual files for Chapter 7 bankruptcy, you have to cease all collection efforts. It's basically a wipeout of all their debt, and provides them with a fresh start. So they'll discharge the debts. And if they do receive a discharge and the association has past due assessments that were discharged, they'll have to write those off. You can no longer attempt to collect those. More common, especially with the collections of assessments, is the Chapter 13 bankruptcy. Again, you have to cease the collection efforts. Otherwise, you'll violate the automatic stay. You'll have to file a proof of claim. And what that proof of claim does is essentially put the amount of money that the association is owed into a payment plan that will be paid typically by the trustee, but is funded through payments made by the debtor in this case. They typically last 36 to 60 months, so it's a longer process. The payments are not always the same. Every month's payment could be different depending on the different money the trustee has to pay towards other creditors. It's a longer process. It typically happens when a co-owner is in a situation where they can't pay and the association might move forward with a foreclosure or something like that. But that is an option. And then at the bottom there, it's important when a bankruptcy is in place that there's good communication between the board or the property management company and the attorney handling the bankruptcy on behalf of the creditor. For instance, you have to provide 21 days notice to the bankruptcy court of an assessment increase. So if the assessments are 200 and then they're going up January of the following year, we would need 21 days to update in order to modify the plan so that the bankruptcy court and the trustee knows that the new assessments are not 200 anymore, they're 250, whatever the situation might be. Okay, so this is our last substantive slide here, streamlining the collection process. So there's a few different ways that can kind of streamline people's abilities to make payment and sometimes reduce the amount of delinquent accounts. So obviously ACH or auto pay is a great tool. The co-owner can set that up, the owner can set that up, their payments will be automatically withdrawn, and there's no issues, assuming they keep track of their auto pay and their account isn't deficient or something like that. But auto pay is a great tool as long as it's working properly. Another issue that comes up with auto pay is when co-owners don't adjust their auto pay to account for an increase in assessment. So that is something to look out for. Credit card and debit card payments, another way to streamline the collection process, allowing somebody to make their payments online. There are processing fees involved with doing that, but it could potentially be cheaper than postage or mailing another delinquency letter or mailing a check, and it avoids delinquency administrative expenses. Okay, so that was collections of assessments your community association needs to know in a nutshell. Obviously, that's a lot of information to digest in an hour. Every case is different, every matter is different. So, keep that in mind. These are just bite-sized pieces that you may walk away with and find something useful, or recognize an issue that you might think you need to talk to an attorney about to discuss. But with that said, if anyone has any questions, for me, I'm more than happy to answer them or let you know if it's something we need to talk about, further offline here. But if you have any questions, I'll open the floor to that. Okay, I'm not seeing any questions in the chat or there's only I think 7 of us here, maybe 6, including myself. But that said, if there's no questions, I'll go ahead and end there. If you do have a question or you have a situation and you would like to talk about it, feel free to send me an email, call the office. More than happy to help you with collections for your communities. So if you don't want to do, if you don't have a situation right now you want to talk about, feel free to contact me offline. And with that, I will go ahead and stop the recording, and everybody have a good night. And I hope this was useful, and I hope you all can take something away to help your associations. So thank you for your time.